You can hear me properly.
I can hear you. Yes.
Hello and welcome to the Daily Lawyer podcast. This is our YouTube live series, and this series is typically small educational videos where we answer questions that are usually asked by you, our audience. And in today's question, or we've had this question multiple times on across all our social platforms, and this is to do with the world of venture capital and private equity, the world of funding as it is commonly known in startup circles. When I look for guests who are experts in their field and they can answer the questions that are commonly asked by our audience, I typically have to sort of hunt and see someone who's absolutely perfect for that field. But today I did not have to hunt at all because my guest today is a veritable expert in this field. I'm speaking about Prachi Dave. She is one of the managing partners of Dhaval Vussonji and Associates. It is a boutique law firm in India, and she's also recognized as one of the top lawyers in India by Legal 500. She is ALB's 40 under 40 top lawyers in India. And I am so grateful that Prachi was willing to give us her time to answer these three questions that are most commonly asked in the world of venture and private equity funding on all our socials. So, Prachi, welcome to the Daily Lawyer Podcast YouTube live series, and thank you so much for your time today.
Thank you, Jenna. Thank you. Those are really kind words. I hope I can do justice to them.
I'm sure you can. So I think we have to start from the most common question that we are asked, which is what is, people use PE, which is private equity, and VC, which is venture capital, quite interchangeably. So
Yes.
if you can just start at the very basic and say, what is this PE and VC for those who don't know?
So, basically, it's a form of money that you raise from a select set of investors. Now, in the life of a company, when it starts, there are a few stages starting from seed, going to angel, then moving on to venture, and then finally going to PE to become thereafter a public company where you can then go out to a larger pool to raise funds. So, really, it's about the time at which you raise this money in the life of the company, and that with that comes the risk associated, because the more early the company is, the higher the risk is. And the more you go towards the public stage, the lower the risk becomes in terms of, we've seen the business stability, we've seen certain amount of repeat relations, whatever, so depending on the business of the company, by IPO stage, you're able to assess where the company stands in terms of its stability of the business relations and accounting and everything. Whereas in the early stages, it's a very, like, first is you're just testing whether this product at all is a viable product. Then when you come to some sort of viability, you'll have some sort of money which will come to say, all right, I'm giving you another lease of life. So these are just leases of life given to the company at different points by different people who find value in the business of the company, very simply put.
So then, would you say that when you say private equity, is that at an earlier stage and ventures at a later stage, or how does it work for those who don't know anything?
No. So PE comes at a later stage. So but like I said, and I think that's why in the market also it's kind of used interchangeably, because although it comes at different life cycles, at least legally speaking, the protection that an investor needs is almost the same in terms of the kind of rights that you'll want to protect, the kind of control that you'll want to maintain, the kind of exit that you'll want to ensure. Those kind of rights are pretty much, I would say, common and similar in both of those, and that's pretty much why we use it synonymously. The difference comes in the finance sector, where they look at it in terms of numbers and number crunching. The life cycle of that investment is looked at little differently, and that's the key difference, really. But if you see in a pure legal arena, the protection that the investors need is almost I would say, identical for both sets of investors.
And now, if I have to take what you just said when it comes to protection that the investors need, and I mean, that really leads me to the next question, which is uh, what are some of the general sort of risks or pitfalls, uh, in a general sense for VC or PE? Uh, and how does it really work? As in, do I take a stake in the company or what happens?
Yeah, of course. See, this money, the reason early on people want this money is because this is not a money that is a guaranteed payback money. So that's the fundamental of it, unlike a bank loan, which of course you have to pay back, and it comes with a fixed repayment or a fixed even interest schedule, right? So in the early stages, when the company does not have stable cash flows to service a kind of loan, or maybe doesn't want to take that because it may it may not have it may have a liquidity mismatch, or it may not have pool of money available immediately at that time, so that you may want to have flexibility in terms of when you repay. When you do repay, it's a high cost, and that cost is really a stake in the company, that somebody who believes in your business is, kind of buying into your company. How, as legal experts, at least how we would look at the deal from, I mean, once somebody has shown a commercial intent that yes, as a business they are interested in this and they see value in the business, as lawyers, I think the initiation happens typically always with a due diligence, because these are early stage investments. So you have to find out everything, the kind of contracts they have, the kind of entity it is, what kind of rights do, if there's one partner, that what, more than one person, then what kind of rights are shared between those partners, what kind of vendor contracts they have, what kind of compliances they keep, because that's also something that is important. So initially, what we do is we do a business eval in terms of corporate diligence, where we identify that these are the areas where it's lagging, and we should pull up these areas. So, for example, if you take like a pharma company or something, which is heavy on approvals, etc., you may want to, yeah, you may want to highlight that, look, this is something that we should take, because if you don't, then the director liability or the shareholder liability could be a problem, right, in the future once you buy into it. So let's fix this problem before we step into it. So we do a diligence to identify where the risks could be. We make ensure that the compliance checklist is fully met, and we tick all the boxes, etc. So once we have the basic sanity check done, either thereafter or maybe side by sides, depending on the timelines, we also evaluate if we were to buy into this company, through what mode would that be. So of course, like I said, these are all equity instruments, but equity, quasi equity. So it could be in the form of a CCPS, it could be in the form of a CCD, it could be in the form of an OCD. So it could be either compulsorily convertible.
I think you may want to clarify what is all that.
Yeah, so they could be compulsorily convertible preference shares, or compulsory convertible debentures, optionally convertible. So it depends on the arrangement that you agree. Whether you want, so in a CCPS, which is a preference share, you have a slightly better standing in liquidation than a pure play equity holder. And you also get, if the dividend is not paid out, so suppose you want some amount of annual dividend, right? You don't want a bank loan service kind of a thing, but you do want at the end of the year, say, a marginal amount, if profits permit or whatever. At least a preference shareholder is assured that kind of a dividend, and if that dividend is not paid for consecutive years, you have certain voting rights which automatically trigger, etc. So those kind of structures you have to evaluate, and all this we have to do, most importantly keeping in mind the regulatory framework. So you have to see whether, if it's an offshore investor, whether you are under the foreign investment laws permitted to make that kind of investment, what kind of valuations you have to buy them at, whether they want to sell it out when they do exit, if they want a sell back option, they want to sell it to other people, they want to be locked in. So those kind of things we have to evaluate in the regulatory framework, especially if it's a regulated sector, like I mentioned, like an RBI NBFC. If you have to buy into that, it could involve taking approvals from the regulator for that kind of investment. So then we go into regulatory framework and tick all the boxes that if this were to go ahead after we've put together the way forward, that if this were to go together this way, then what are the kind of approvals and compliances that we may have to take for this particular investment. So we look at that, and a very key aspect, I think, that from a legal perspective that we always have to make sure in the documentation is plugged is management control, because we all everybody would want some sight of some line of sight in the business, so whether you want a board right, whether you want a veto, whether you want an affirmative, and if yes, then to what kind of rights do you want to get into, I mean, and personally, I would not advise an investor to go too much into micromanagement, because ultimately you are an investor and what you have to look at is that your money is secure, and leave the day-to-day business to the promoters who are running with the ball. So, while protecting their interest, allowing some sort of operational flexibility, I think that's very important, because otherwise it tends to cause a unnecessary friction. So the kind of vetoes that you want to have, nobody's saying you don't have control. Yes, you should. But to what degree, those kind of nuances we need to look at. Director liability, because most people want to become or have the right to become a director at some point, but to understand director liability in the Indian landscape, especially for foreign investors, where independent directors, nominee directors don't enjoy the kind of immunity which some of the other jurisdictions do offer. So then sometimes it becomes more, you bite off more than you can chew. But at least we put that all out on the table so that, people are aware at the time the investment is being made on what they are signing up for.
So, if I have to condense what you said into, say, 3 or 4 points, when you think of risks or pitfalls associated with, say, any sort of VC or PE investment, whichever side that you're in, whether you're an investor or you are seeking the investment, there are four major buckets that you are thinking through. The first is really the form of the investment, because unlike a bank loan, you're giving the money and you don't have a defined return. It may be zero, it may be minus, or it may be great amount of plus. So the various ways that you can make the investment, and you mentioned about the various types of shares and debentures that are possible. The second bucket is the management control, where you can have what kind of how much control you want to have in the voting share and so on. The third bucket is the regulatory framework that surrounds that particular business that you're investing in, and you as an entity
Yes.
who is
The
being
deal
governed.
itself, the kind
Yeah.
of regulatory framework, the deal itself would have to
Yes.
comply with.
Yes. And of course, if there's a foreign entity involved, then there are foreign regulations that come into
Yes.
play. And the final bucket is the director's liability bucket, which, as we know in India, some describe it as fairly onerous, but it is quite a responsible job, and sometimes we don't understand the contours of that job. So these are the four really big areas that you have to consider when you are taking an investment, which is probably why it's always a good idea to have legal support from the beginning when
So,
you're
these are from the investors' angle. I would say if you were on the sell side, like if you were on the promoters end, some of the things that we have seen cause pain, especially not at the time of investment, but if, God forbid, things don't go well, then anti competitive clauses, the non compete clauses, which are typically built in, because what happens is ultimately, if that company and its business doesn't do well, the promoters still need to have an alternative line of business as a source of income for their livelihood. And Indian courts are very clear that any clause which absolutely prohibits their freedom to practice trade or blocks livelihood will not be upheld. So when we look at it from a promoter's end, we have to make sure that business is, tightly defined, and, you're not signing off on something that you will then later on regret, because whatever said and done, there is some amount of heartburn, even if the courts don't finally recognize it. We don't want to get into unnecessary discussions and notices with the investors, and it's better to then make that position clear upfront, have that discussion that, if things were to go south, which can happen in this at this stage of the company's life, then this is what I would be able to do independently, and you will not kind of interfere in that, and obviously at all times I will, as a promoter, make sure that I'm looking into this business, and it's not some business which is going to compete directly with this business during the life of this company, etc., etc. So, those are some of the things from a promoter's end that you would have to look at. Like I said, operational flexibility. It's very important as a promoter to make sure that we are not having to run to the investor at every check signing. It cannot, I mean, you cannot survive. It just causes a lot of stress and chaos on the system. And we don't want that, because already it's, you're anyways doing an uphill battle in terms of trying to grow the business. So having to deal with any additional unnecessary kind of stress becomes a little bit challenging. Also, from the investors end, I mean, this is there are two sides to it, but a lot of investors prefer having a whole bucket list of things, that I will control this, I will have these many directors, I will become a signatory to these bank accounts, and I will do this and that, and ultimately don't end up exercising a lot of those. At least we advise that don't do that, because in a lot of cases where ultimately things are going in a, and it's not looking too good for the company, some of those rights the courts have said that, oh, you took those rights, you didn't exercise it, you're in collusion with the promoter, you try to defraud the third parties and the banks. So if you're taking a right,
That's actually a
be
really good
mindful.
point.
Yeah, yeah, so if you recall in that I was in Amrapali or Supratek, I can't remember now, but in one of those judgments, the Supreme Court really pulled up the investors, and he said, you had the right to do one, two, three, veto this, see the business plan. You did nothing. You let the company dwindle away all its money and swindle away all the investors. Other than you took back your money. You are in collusion. So, you have to make sure that the rights which you're taking, they have to be responsible rights. And you have to exercise them responsibly and monitor the company appropriately, right? So I think those are some of the pros and cons that you have to kind of balance when you're walking the walk.
But this is very useful, Prachi, I think what you said, because you gave a very practical view on this, and it is also a very balanced view, so that people can, take these lessons when they are probably negotiating whichever side of the table they are at. And now this actually brings me to the last question, which is, what are some of the tips that you would have to give either side of the table, if they find themselves in a position where they are either looking at a target for investing, or they are seeking investment, whichever way, PE or VC?
See, if you were looking at investing, I would say don't take diligence lightly. Whatever said and done, especially because the smaller the company, the more likely it's been run like a mom and pop shop, and it's not really been up to speed with entirely with the compliance. So I would say, I mean, that's not something you should give a go by to. You should always do a sanity check before you step in. After you step in, I think division of power is extremely important for a viable running of the company. What you will do, what I will do, when you have to come back to me, that kind of balance should be very well agreed upon right up front. And I would say, like I said, let's not overreach in the agreement and, try to stifle the business, or try to, put rights in which could potentially hurt him and or hurt you both ways. So I think those are some of the things from the investors end that you should definitely be considering. And I think from the promoters and before you go out there, like I said, they should also undertake some sort of a sanity check, because you do want to be in a good shape when somebody is assessing you, because that also shows the manner in which the business is likely to be conducted, and that you do take compliance seriously, and you do take laws seriously. And because that's what shows the investor that yes, you are somebody they can put their confidence in. Because if you're just going to be blasé about everything, it kind of makes the investor also a little bit jittery, that I don't really
Yes.
know what kind of guy this is that I'm getting into bed with. um Exit rights, anti-dilution, those are things that should be discussed, because the company may need another round. So how do you make sure that that option is open? We don't block that option, but at the same time, the value that the investor has put in or is putting in today is still protected for him for the future round. What kind of balance will we come to if there was another round? So those are some of the things that as a promoter we will need to keep in mind, because we are going to likely need another round or two rounds. We don't know. So and when is the exit proposed to be? Because when the exit comes, there are some kind of tags and drags, etc., which do get attached to the promoter shares. So when are we projecting the cycle to end for this particular investor? Because that also depends on the promoter. So because that is when, if I say it's happening in 2 years, then if it doesn't happen in 2 year, third year, likely they will want my shares also to be sold to a third party, right? So those are the things as a promoter that should be well thought out.
Yeah. So for now at least, I mean, Prachi, honestly, I think I can have a longer conversation with you because
Yes.
you clearly have a lot of lived experience in this field. But unfortunately, our time for the live is only 20 minutes. These are just very short videos that we do because most of these questions are asked by the audience. So if you all want Prachi back on the podcast, I think you should all comment and say we want Prachi back on the podcast. But thank you so much. It was so kind of you to give me your time today.
Thank you, Jenna. Thank you.
And
My
I hope
pleasure.
to have you on a full podcast soon.
Yeah, absolutely. Anytime. Thank you.